death, when I pass away, there is the divine distribution. Yeah, you can't do anything with it because this is after your death. That's a divine distribution. However, after my death, 1/3 of my wealth goes to the masjid, for example, goes to this charity, goes to this orphanage place, goes to my friend. This 1/3, you can do whatever you want with it, with one exception. You cannot take this 1/3 and add it to one of the members of your heirs and inheritors who are automatically going to receive the rest of your wealth. So the 1/3 has to be distributed to any party except the heirs and the inheritors, because they already have their divine distribution. The 1/3 goes for a stranger, goes for the Islamic Center of Raleigh, goes for any charitable organization that you feel very comfortable. Of course, we are making this awareness and we're highly encouraging that you do that 1/3 to your masjid, because Allah subhanahu wa ta'ala made it, not because we're special or anything. This is part of our responsibility, that Allah subhanahu wa ta'ala started with the risala and the message and told Prophet Muhammad sallallahu alaihi wasallam to give da'wah to the closest circle. وَأَنذِرْ عَشِيرَتَكَ الْأَقْرَبِينَ, that give warning to those who are around you. I'm not going to jump the world. I can't control the world. I can't control what's happening over there. What I can control is the atmosphere around me. And I do trust my masjid running all these programs, running all these educational projects that are targeted and aimed to establish Islam and to establish the Muslim identity, and that brings about stability to this faith within this land, within our community. So that's where I want my money to go, especially that you assign it to go for a continuous charity. So I don't want that 1/3 to go for example, electricity and fixing the parking lot. I want that 1/3 to go for programs within my masjid that builds schools, that builds educational, financial scholarship, that builds whatever, builds another campus masjid where it brings services to other community members around the. So you can say that, no problem. That would be a continuous charity. Or what we are highly encouraging now, being a little bit more smarter, is the fact that we are pushing everyone toward the waqf and the endowment concept. Because honestly, with the 1/3 you're going to leave, what's going to happen to it, even if it goes to a very, very passionate project that you love, again, it's very limited. It's only one project. But we are greedy when it comes to rewards, right? So we want many projects, but I cannot afford many projects. My money would maybe go into one project. But the endowment concept is that the 1/3 would go to a pool called endowment, waqf. That pool does not get touched, but it grows. So let's say that you put $30,000 or $33,000 of your $33,000 of your 1/3 or whatever the number is. Now, instead of being limited to only one project, the 1/3 that you put grows over years, and it gets benefit. And it gives again, because it doesn't get touched, and it keeps giving, and it keeps giving, and it keeps giving. So it ends up serving many other projects of continuous charity instead of one. And that's why we're really trying to make this awareness of endowment concept. And inshallah ta'ala, the rest of the program, we can talk more in the community room. Jazakumullah khair. May Allah subhanahu wa ta'ala reward you all. And just your presence, you are being rewarded. Just the fact that you wanted to come and get enlightened and getting a little bit more of an education and being part of an initiation. Remember, Allah clearly says in the Quran that those who came before the Fath, before the opening of Mecca, and believed in Prophet Muhammad ﷺ, and believed in the message and were the founders and were the pioneers and pushed through something that's very strange and very unacceptable to others. And they went through the struggle. So whoever always come first and establish a sunnah hasana, a good sunnah, they will get the ajr of every single one that comes after them. So let's assume now the endowment is $3 million based on $3 million, and then it grows to 30 million, to 300 million. Down the road, Allahu Alam how many years, you are gonna get the reward of every single one that comes after you. Why? Because you were part of the pioneers. You were part of the establishment. You believed in it from early on, whereas others are very skeptical and they will wait 5 years, 10 years, 20 years, and then it will click and say, oh, now that the 3 million grew to 300 million, now I believe in it. So they will invest at that time. Still good. These are the people that came after the opening of Mecca. They're still good people, but the highly recognized one were those who came before, who established, who planted, who believed in the concept when it was still too early and it was in its infancy. So they're the one that pushed it. They're the one that made it to be recognized and get established. Jazakumullah khair wa barakallahu feekum. Subhanakallahumma wa bihamdik ashhadu an la ilaha illa anta astaghfiruka wa atubu ilayk.
Assalamu alaikum, everyone. Allah khair. All right, so my name is Ahmed Kouka. I'm a financial advisor. My office is in Cary, and I work with busy professionals, families, and individuals, answer the most important pressing money questions in their life, making sure that they are confident about their financial plan and about their retirement. And today I'm here to talk about this important subject matter. Jazakallah khair, Imam Muammar, for that great introduction from a religious standpoint. My role in all of this is part of every successful financial plan for any individual or family is making sure that they have a will or an estate plan. So this is something that I regularly have conversations on with families and individuals all the time, business owners, because I believe everybody should have a plan. So by the show of hands, who here have a will or an estate plan that they have worked with an attorney that is notarized and up to date? See, one person, 2, 3, 4. Perfect. Of those 5 people who raised their hands, who of you have reviewed or went over their will or estate plan in the last 3 years? 1, 2, 3. So 3 of the 5. Perfect. Thank you. For everyone else, guess what? If you don't have an estate plan or will, you do have a plan. It's not necessarily your plan. It's Uncle Sam's plan. So Uncle Sam is waiting for you. If you don't have a plan, they love it. They have a plan for you, and they'll make sure they'll take care of your assets when you're no longer with us. And without saying too much about this, this is why it's important to have our own plan. We have a divine distribution that, that's not going to be aligned with the law of the land. So if you want the divine distribution to go, you need to go today and start that process of having an estate plan. So what is an estate plan? What is a will? What's that? Yes. Is this better? Perfect, okay. So what is an estate plan? On a very high level, and Jeff will be talking about it more in more detail, I just want to make sure that I cover the high level aspects of it. Well, an estate plan, what differentiates an estate plan from is just a basic will, the will that Imam Muammar talked about on the website. This is just a standard basic will. It talks about distribution. There's a table that talks about all of this. And that's what I will. And it talks about where you're going to be buried, asset transfer, distribution, things of that nature. And if you got it notarized, that's the bare minimum you can do, to have something in writing to state your wishes after you're no longer with us. an estate plan goes a little bit further. It has a lot more to do with everything money and relationships in your life, right? So it talks about asset transfer, which is sometimes covered in a will. And if you're a business owner or professional or have a lot of assets, it goes into the details of different types of assets and how everything is distributed and who gets who. So it's you speaking out of the grave in stating your wishes based on the divine distribution. It also talks about incapacity protection. So you're alive, but you cannot make your own financial or health decision. An estate plan covers that as well. Guardianship for minors and dependents. If you have minors, special needs people, dependents, parents that you take care of, and you don't have a plan in there, the estate plan covers that. Whether that's a sentimental kind of taking care of, like assigning a guardian to take care of them, or a financial standpoint, assigning certain level of assets toward those dependents, or special needs people or children, so we can make sure that they're taken care of as they age. Charitable intent. If you want to be specific with your legacy and charitable intent, the 1/3 Imam Muhammad mentioned, an estate plan covers that. We would have that conversation and we talk about it. Tax planning. Gifting and tax planning is a big part of an estate plan, making sure that you minimize the amount of taxes that you're going to pay in your life, but also minimize the taxes that your heirs will pay after you pass when they inherit those assets. There's a lot of tax implications and consequences, and a lot of people are surprised when they inherit assets that they have to pay certain level of taxes, especially on qualified or retirement accounts, IRAs, 401ks, or probate assets. Business succession. If you're a business owner, who's going to take care of the business? So just like for guardianship strategy, you're going to take care of minors. A lot of business owners, when I talk to them, they always tell me, my business is my baby, right? So who's going to take care of your business when you're no longer with us? Is it family? Are you going to exit that business? Are you going to sell it? So these are important questions that we need to think about. And if you sell it, what's going to happen to the family? It's an asset. So who's going to be compensated? Who's going to buy it? Who's going to pay the value of that asset? So there's a lot of questions around that. So that's why this is important for every single person here, for every one of us. So how can we help? So this program that we started with IAR is forming a team. It's a team's approach, right? When we talk about estate plan, the number one reason when I ask people why you don't have an estate plan, the answer is, I don't know where to start. It's an overwhelming process. There's a lot to go into play. There's a lot of details in it. And the more assets, the more things that you have, the more complicated it gets to make sure that our will and estate plan aligns with the divine distribution set by Allah. So that's why you need to form a team. And a lot of us have many pieces of that team. So a lot of us have CPAs or tax preparers that they work with. Your tax preparer and CPA is a very important part of the team. You need an estate attorney to draft the documents and the legal paperwork. That's why if you have an estate attorney, that's great. We're happy to partner with that estate attorney and work with them and make sure that they are aligning everything and explain to them the divine distribution that needs to be. I personally have been partnering with Jeff for so many years, and we've worked together with so many Muslim clients, so he's very familiar with the divine distribution and what's needed. So if you don't have an estate attorney, Jeff is a great resource here that can help with that. And a financial advisor. I tell people, they always ask me, okay, what's the difference between you and a CPA? Well, think of it, the CPA is always looking in the rearview mirror when you're driving. Your financial advisor is looking at the windshield. We're looking ahead, right? What's going to come ahead, we're planning, we're implementing. And I like to think to myself, I tell my clients, I'm the glue that puts that team together. So the process starts either, if you want to go full-fledged estate plan, it starts by having conversation with me. We form the team, we talk about the plan, action items, and how long is it going to take, and then we start working together, and we start bringing everybody to the team as we go through this process. And of course, your masjid, right? We all love our community. We're all part of this great community. If you have charitable intent and you want to give a share of your net worth or your wealth after you're no longer with us, the masjid is here to help in that process. And to be honest, that's one of the ultimate goals. That's why part of the reason why the masjid is involved in this. Of course, we want to give back to the community, make sure that everybody has a will and estate plan, but it's your decision. If you decide you want to give back and you want to give that 1/3, the masjid is happy to help either way and be part of that process as part of that team. All right? And with that, I'll be available later on in the community room. If anybody has any specific questions or want to talk about it more, I'm happy to answer. And allow me now to introduce Jeff Marsace to take us away with more detailed conversation about estate planning and wills.
Thank you very much. My name is Jeff Marsace. I am an estate planning attorney, and the way I got into that really has to do with my own family and my experiences. My grandfather passed on just about 2 weeks before I was set to go away to law school. So I got to law school, and my grandmother was a very proud grandmother. My grandson's in law school. She gave me one day and then started calling me up and asking me legal questions about the estate. Well, I learned very quickly there is one most common answer that you ask any first-year law student. They're going to give you the same answer, and it doesn't matter what the question is. And the answer is, I don't know. Let me look it up in the law library. So she would periodically call me with questions about the estate and what was going on with my grandfather's estate. She didn't understand. She had an attorney, but every time she called, she would get an answer she didn't understand and a bill that she didn't want to pay. So I'm running around and finding out things in the law library, and then I suddenly realize it's been a year and a half, and these questions are still coming, and the estate still isn't settled. And so I started to think about, how can this all be avoided? It can't have to be this way. And so I started doing my research, and then I went to the head librarian, and I finally said, look, this is what I'm trying to do. What's out there? He said, oh, I know exactly the book that you need to read. We don't have it here. He sent me to the local mall just a few miles away from the law school, and I found a book called The Living Trust. And it's a way to avoid the probate court process while still enacting the wishes that you have. And so this really became a big point in my whole practice for the last, we're coming up on 27 years. It's structuring how you do things, because what you put into your estate plan is just as important as how it ends up being executed on the other end. So the big thing with my grandmother through that entire year and a half, it was really the house was an issue. There was a problem with the deed. And so half the house was in this court process. And I'll never forget the way she told me. She just felt so frustrated. She said, I feel like my house isn't really mine until this is done. And so that led me to put into my practice, how can I help people avoid that for their families? So I found this living trust, and I really did everything that I could to try to simplify the estate planning process. How many people here are so eager to call up an estate planning attorney on Monday and meet with them and talk about what happened? It's not something that people generally want to go and do, but they know they have to do it. So I try to make it as easy as possible. So I've tried to boil things down to just 4 big questions, which hit a lot on some of the things that we had in the slides before. Really, the 4 big questions, first one is, who do you want to handle financial things for you if you can't? So that's naming the people who would be in charge of making this plan happen after you're gone. But also, the other thing people don't want to talk about is, what if you're incapacitated? That person would also be stepping in to help manage things for you. Second big question is, who do you want making healthcare decisions for you if you can't? So who are the people you want in charge who are going to make good, smart decisions based on what you would want? Third big question is the estate piece of it. It's who gets what, when do they get it, and how after you're gone, and that's where you have your distributions, and you can discuss what's going to different charitable organizations and to the family. That's the third big thing. And then the fourth one, when I ask this question of some of my older clients, it's, who's going to raise your minor kids? Have you had any children since we filled out this paperwork? And I see a couple in their 70s saying, well, no, we're not having any more children. So usually it's only 3 big questions. So that's fine. So when we get the answers to these questions, it doesn't matter if it's done through a will or through a trust, but the trust is a way to take it out of the court process. Now, how is this exactly happening? It's because probate court is governed by what ends up in a state is what's still titled in a deceased person's name after they pass on. And so this may be why some issues with a judge saying no to a plan. If you put in your will, here's exactly how I want things to happen, but somewhere along the line, perhaps a 401k that you had set up with work, someone from the HR department many years ago might have simply put in who the beneficiaries were going to be. Well, the will doesn't cover it. The will only covers what goes into that court process, and so this may go by designation of a beneficiary, and it's not what you wanted with your overall plan. So one of the things is to make sure it's coordinated. With a revocable living trust, assets are titled in the name of your trust. You're still in control of all of it because you're the trustor, you're the trustee, you're the first level beneficiary, and then we incorporate all those estate planning wishes from that third question, but it keeps it out of probate court after you're passed on. It also keeps it from becoming a guardianship proceeding if you become incapacitated during life. So you don't have to report to a court and have a guardian assigned. The trustee just takes over whatever's in the trust. Now, there are a couple of specific documents that I'm going to mention that make all of this happen. It's a will or it's a revocable trust as your main piece of the estate plan, but you also need a durable general power of attorney. So this is who would be making financial decisions for you for everything outside the trust. And they're the person legally who would take over and file tax returns, apply for benefits, and things like that. The healthcare power of attorney is the person who makes these healthcare decisions for you and the people that you're naming in case you can't make those decisions yourself. There is also a living will that's really just designed for what if I reach the point where the doctors have said there's no coming back. We've got a lot of great medical technology to keep a body going, but that's not necessarily what most of my clients want. If they mainly say, look, if I've reached that point, just let me go. And that's their wish. That's what that document is for. And then we also do have a nomination of conservator form, which would name those guardians through a court if it ever got to that. But we're lining it up with that same trustee list for being your conservator of the estate, and we're lining up your healthcare people as the conservator of the person. And the idea is a lot of these other documents make this unnecessary. So that document is to say to a judge, we don't need to do this, we have these other documents. So those are some of the big documents in estate planning that empower you. Otherwise, like it was mentioned, the law just takes over and it's whatever the government chose as the default ends up being what you're stuck with if you don't put your plans in place ahead of time. Now, I did want to talk about 4 big downsides of probate. The first big downside of that court system, like I said, how things get distributed, it's expensive. It's anywhere from 4 to 10% of an estate gets eaten up by costs and fees, and honestly, paying an attorney to handle that paperwork. If you can avoid probate as much as possible, you don't have nearly as many of those costs. Second big downside, probate has delays. Typically, it's 6 months to a year and a half, and sometimes things just get complicated, And it really isn't uncommon for an estate to go more than 2 years. Thankfully, my grandfather's estate got closed in just under 2 years, and my grandmother got the house. But it was 2 years that she had to wait, and she still had that feeling. A third big downside of probate is it's easier to contest. And this ends up being a big deal. Here's the practical thing. If someone is contesting an estate that's in that probate court process, it's actually kind of designed to take on these challenges in a very efficient way for the person who's, quote, creating trouble. I don't like what's going on. I'm going to go to court. I'm going to find an attorney. And the big thing is the attorneys tend to get paid out of the estate for doing this challenge. And so a lot of attorneys will say, okay, let's roll the dice and see. I think there's something I can, quote, hang my hat on. If it's with a revocable living trust, it's a whole other thing because it's not in that court process. They actually have to file a lawsuit. And attorneys don't typically get paid out of the estate for that. They have to win and win decisively. And so no attorneys are going to take on those cases unless they're paid up front. And one thing I've found is people who want something that they're not entitled to rarely want to put up their own money to try to get it. And then the fourth thing is privacy. Anytime an estate goes through that probate court process, all of these inventories have to be filled out with exact values on the date of death and what were the expenses, and they want copies of canceled checks and all these other things. Those are court documents. So anyone can actually go in and see what's going on with that estate. And it's been a while since I've been up to the courthouse. They do things a little bit differently now. They want people to mail things in, but before that, there were marketing people going through all the probate files to see who's going to be getting an inheritance at some point. And this is going back more than 10 years, but I had a client, he called me up and he said, Jeff, I've got a Friday afternoon question for you. Basically what he was saying, it was a Friday afternoon. He was only going to ask me the question and get an answer if I wasn't going to bill him. And I said, fine, go ahead. My dad died in Michigan about 4 months ago. Does that have anything to do with the fact I'm getting all of these brochures from Mercedes and BMW? And I was like, yeah, you're on a list now because his estate went into that probate court. So the thing with the trust is it avoids all of that because none of those assets are something the court has to deal with. It's already taken off the probate court docket. So it happens privately, run by the person you've chosen as your trustee, and it only could potentially get to a court if they're not following the directions that you put in the trust. So I wanted to just close out, talked about the endowment and that there are different ways to incorporate that into an estate. But again, getting to how things are done, there are actually 3 potential tax savings techniques that can be done if you want to donate during life. And I'm just going to use the number $10,000. If someone wants to give $10,000 to the endowment, how would they want to do that? Well, you could always take the money out of a bank account and donate it. But what if you have some stock and you bought this at a very low price? Let's just say you bought it at $1,000 and now it's $10,000. If you sold that stock, you'd have to pay capital gains taxes on $9,000 of gain. Well, if you take that money and give it to a charitable organization as that donation instead, they don't pay capital gains taxes when they sell the stock. And then you can take your $10,000 and put it back into repurchasing stock, and now suddenly that cost basis is back up to $10,000. So if you're going to give that anyway, perhaps giving that stock. Another thing, retirement accounts. This is something that I definitely let the CPAs go over the exact numbers. But if you were going to give that $10,000 and you have a retirement account and you're over the age where you're not paying penalties or anything, and well, okay, I could take that money out in order to give that. If instead you had it go directly from your retirement account to the charity, then it never hits your income tax, even though you could get deductions. However, from what I found with some of the new tax rules, it still counts as part of your taxable income, which could affect the tax rate for your Social Security income. Okay, why would you want to do that if you can just have it go directly? And then a third thing, sometimes I have clients that are involved in business, they have property. And the property has either accumulated greatly or they've actually taken depreciation deductions on it and they want to sell it. And then they talk with the CPA, it's like, okay, here's what the taxes would be for capital gains, and sometimes it's even counted as ordinary income if you've taken that deduction. It's like, this is just gonna be a huge tax mess. They can donate the real estate to the charity can sell it, and by an agreement, get a stream of income over several years so that tax gets spread out, and it's a lot less than if they just sold the property. So there are lots of different ways to incorporate a charity in giving now where everybody comes out ahead except for Uncle Sam. So that's a goal for some of my clients as well. So with that, I'm just gonna go ahead and close it out. And I look forward to questions later.
Thank you so much, Jeff, and thank you, Jazakallah khair, to Imam and to Ahmed, and to everyone else for joining us tonight, alhamdulillah. So we're gonna move to Q&A real quickly in a second, but I wanted to discuss quickly why you have an Islamic will, and why do we follow these Islamic steps? And I'd like a volunteer. Would anyone like to volunteer to tell me a bit about their family? No one? I'm gonna have to use the Imam's family here as an example. Perfect. Volunteer? Yes. So perfect. Volunteer right there. I'm gonna tap you real quickly. One sec. Yeah, you tap here. Okay. So what are your next steps? Our next steps in this are we're going to do a Q&A, and then we're also going to offer you the resources to Jeff, our wonderful attorney, as well as an online service called Sharia Wiz, which everyone has might have heard about, but they're giving us a special coupon code for the masjid. And I'd like to show you their calculator, which you can use in any type of will that you might go with. So your third approach is, if you decide, I don't like any of the suggestions IAR has given me, you can go get your own independent third-party will, and IAR has retained Raqaba as a service, or we are retaining Raqaba as a service. They're a Islamic Sharia compliance law advisory firm, and for a nominal fee, they will review your will if you get it from a third-party provider. But we highly recommend going through Jeff. So I just want to show you those minutiae of why an Islamic will and the criteria of going through the Islamic method are so important. So our beloved volunteer, I'm gonna actually give you the mic. You put yourself in the spot. So there's a wonderful inheritance calculator here. Brother, you're going to help me work this out, okay? We're going to say you follow the majority of all the madahib. And how many children do you have?
3.
You have 3 children. So traditional will might separate that 1/3, 1/3, 1/3. Each child gets 1/3. But we want to follow the Islam. We want to follow the Quran and the Sunnah here. So brother is a brother. Are you married by chance?
Alhamdulillah.
Alhamdulillah. Is your father alive?
Nope.
Allah grant your father Jannah Firdaus. Grandfather?
Nope.
Great-grandfather?
Nope.
Mother?
Nope.
SubhanAllah. Grandmothers?
Nope.
Children, you have 3, as you mentioned. How many sons?
2.
Alhamdulillah. And 1 daughter, I'm assuming?
Alhamdulillah.
Alhamdulillah. So here is a quick table that shows the importance of why you want to go through using Jeffrey or using the services the masjid suggests, as opposed to maybe just any off-the-shelf will product. Islamically, you'd have to define things into specific percentages for each of your heirs. You have another 1/3 you can give to whatever cause you want, but specifically, you have to give 35% to each child, 17% to your daughter, I believe, and then 12.5% to your wife. So it's important to follow the Quran and the Sunnah and to use the resources that IAR is providing for you. So now we're going to have a quick Q&A, inshallah. We have a brother over there and a sister over there. Can I ask you to give the mic to the brother? See, now you're the volunteer for giving the microphone around. Alhamdulillah.
My question is, and I'm not trying to change anything around, but what if you have sons, but they're not Muslims and they're out in the streets? You don't want to give money that might be thrown away. So how do you handle that?
That's a great question.
So that's part of our divine legislation that Allah subhanahu wa ta'ala doesn't allow that. So you cannot give out an inheritance to a non-Muslim because of the reason that you said, that they might end up spending it with something that does not incline with our Islamic values. So as you are aware of it, you're gonna always have to, that's what the Islamic will says, and put these guidelines that this inheritance has to transfer to another Muslim. So this would be covered within your Islamic will as well. And you're gonna of course go through each line and sign on it that this is your wish. Unless of course something changes and those sons or daughters become Muslims, then it becomes a divine obligation for you to change that. No, actually you're not gonna change anything because your Islamic will say only if they are Muslims. And since they're not Muslims, then you can always take them out, or you can just deny them from that inheritance.
Imam Muammar, I have a question for you, inshallah. Yes. So as suspected, a majority of the people here don't have a prepared estate or Islamic will. Is there a basic will or maybe something handwritten that we can put in place for ourselves to say, A'udhu billah, if we died today, for example, we didn't have this in place, we had the niyyah to go and put this together as we learn, but that if something happened to us, it could say, please contact this person at this organization to ensure that my assets and things are distributed, my burial has taken place based on what Allah has revealed, right? Is there something that we could just temporarily put in place until we get a full will with in-depth description of how we want things to be distributed?
And that's an excellent question, and the answer is, since we are all aware that this is a process and it will take time, is to go minimum with the Islamic will that we have online. So that's the one that you would sign on it, and it would specifies everything that you said. And then again, you're gonna notarize this. You're gonna hold a copy. The one that you assigned as an executor to your will have a copy notarized. And then we used to, as an Islamic center, keep a copy. So we're not guardians, but we just keep a copy. We no longer take this, but we're considering doing that service. But then you can always name the Islamic center to be the organization that you want it to handle your funeral procession and all that, inshallah.
Jazakallah khairan.
Wa iyyak.
The actual legal requirement for a will to be effective is it does have to be in writing, signed, witnessed by two people, and then if it's notarized, you don't have to go through a process of trying to find the witnesses to testify under oath that it was in fact signed by them. So that's just kind of the standard. If you're at that point, if you want it to be effective anyway, like you said, use the online version to start with, and then you can go into it. But it does have to have those formalities in order to be a legally binding will under North Carolina law.
understand. Yeah. It's okay. Assalamu alaikum. So, if you have a will that you did yourself with a couple of witnesses and it's notarized, based on what you said, it doesn't hold in court?
If it was in writing, signed, witnessed by two people, and notarized, those are the formalities of a will. I'm not making any comment on what was actually listed in it, but it is valid.
But it was not done with an attorney.
Well, that's
It doesn't
fine.
matter?
Yeah, there are methods to do a will yourself, but it has to at least meet those legal formalities.
Okay.
You can always do your own will. There's an awful lot of information that I've kind of put online in one of those handouts that will go into a lot more detail. The trust is really designed to keep it out of probate. The will says, okay, it is probate.
I have a legal will, and I want to come back and combine it with the Islamic will through your service. In general, about how long does it take to get everything complete?
Depends on the situation and your urgency. We can turn things around within a week or so. We've unfortunately had people who literally were on their deathbed, and we've got it done very, very quickly, like within a day. But usually my clients want to reflect a little bit more, have a session, talk through it. And yeah, and it's at least a couple of weeks for a will. If we're doing a trust, there's a lot more involved. Usually that's more like 6 or 7 weeks, just because they want to take more time at each step.
Assalamu alaikum. What happens in reference to enforcing the will? Say, for instance, someone in the masjid has parents, and also the child has non-Muslim. What enforcement does the masjid have in burial? Does the will has to be registered in the state of North Carolina or, say, Wake County? Does the will has to be registered?
Wills do not have to be registered until after the person has passed on. Now, there is a service that Wake County has, and I imagine most other probate offices in those court systems in each county has, where you can, quote, put it on file. That's not a legal requirement, and what they always do is if somebody passes on, they check to see if they have it on file. But there is no requirement to register it. Mm-hmm.
They're not on the will. They're not on the will. You have someone who's Muslim who's responsible for handling and making sure dealing with the deceased. What enforcement
Okay.
rules does the masjid have to do that?
Okay. So the question is about your final wishes, and perhaps you have non-Muslim children who might try to do something against what you've got. If it's in your will, then it's whomever you've listed as the executor would have the power to enforce that. And if they called me up, I'd say, okay, look, well, first of all, I'm not the attorney to handle that. I know a few who would, but you need to go to court and get this stopped. And usually, if there's some kind of contest that I've just seen with funeral homes in general, if you show them a copy of the will, here's what they want. It's signed, it's witnessed and notarized. And if we have to go to court, they're going to get dragged in. They're going to go, oh, okay, we're not going to do anything until we get some kind of determination here. So there is a way to enforce it, but through the courts.
We've heard from all the brothers. Let's go to the sisters now. But a quick comment on each struggling kind of notary. The masjid does offer pre-notarization of your will. You can just email us at the email that everyone received. We'll also have a copy of the handout. And information for both Tuga and for Jeff Versace. You can reach out to the masjid, and we're happy to notarize your will for you. For free.
Who can you assign as executor? Can it be your child, for instance?
Yes, you can have, really, you can have anyone who is a legal adult, and it's been a while since I looked into that, but they can't be a convicted felon or have any misdemeanor convictions involving dishonesty. The fact is they have to fill out things for the court and submit it to the court. So it's not based on relative or friend or whatnot. It's whether or not there's something that's stopping them from being the executor. But other than that, it can be whomever you want.
Yeah, I just have a quick question regarding the challenge of the will. Like, this sister has said that if some, like, part of the, if nothing is given to, let's say, one of the kid, he's non-Muslim, so can he challenge the will?
Okay, I get that question quite a bit, and I end up going back to a story of my very first day of law school when the dean of the law school came up and said, let me lay this out for you. Anyone can sue anyone for anything at any time. The question is, will they win? Welcome to your next 3 years of law school. So someone can always challenge. It really depends, do they have some kind of circumstance that makes the challenge more valid? And unfortunately, I've seen some of my clients have their estate plans changed at the very last minute after it was very clear they had already gone into stages of dementia because one of the kids took them to an attorney they were friendly with. And okay, that has a good chance of being thrown out. But if it was done and you were clear, everything was laid out exactly the way it's supposed to be, there's no issue for a challenge, yeah, they can try, but they're probably going to lose. Sorry, I couldn't hear the full question. No, under North Carolina law, the only person who is entitled to a share would be a spouse. Other than that, it doesn't matter what the relation is, you can do whatever you want with your property.
Assalamu alaikum. What do you do in a situation concerning an estate? My uncle passed, and he said the land could not be sold unless it's sold to family. Now, his wife passed, but the lawyer sent out letters to the children that we could find, but we only could find one. They don't respond to it or answer it, but they know about it. So what do you do in that situation? The land is just sitting there. Before his wife died, she was keeping the taxes up. My daughter, she's Muslim, she lives on the land, and she wants to do something with it, but she has to do it legally. And she don't know what to do because the lawyer said if they don't sign, nothing could, you can't forward it and do anything. So she's just staying there.
That might be something that if you call my office, we can go into a little more detail, but I would probably have another attorney that I would send you to, since it is kind of like a conflict. Just letting you know, I plan ahead to avoid those types of issues, and if it ends up where, okay, it's contested somehow, or there's some friction, there are other attorneys who are happy yelling and screaming at each other. That's not my thing.
My question is about couples that are both working. So when you were going through the online Wiz website, it distributes 12% to the wife. But if you have shared accounts and everything is in shared names, how does the distribution work? Would it be 50% plus 12% in the Islamic will? How is that distribution done?
I'm going to let you answer that specific one.
Okay.
I could put it into the documents however you wanted it, but there is a specific answer.
So Jeff, to make you feel good, inheritance law is more complex than physics itself. So even your own imam has no clue. So what we do, inshallah ta'ala, is the fact that we are blessed now with technology, is that the distribution has to go, as we said, the percentage. So there is no mix if we're gonna go with the Islamic law. It's just that calculator that gives these shares, and these shares are final. So there is no mix between the shares that you get through the civic law and then also the Islamic. So the Islamic was one, it's just a schedule that exactly like what Kashif did. Someone passes away, left behind a dad, a mom, a wife, 2 sons and 1 daughter, and it just calculates and gives you that share. And by the way, this is exactly what happens in the Muslim countries. So when someone dies, the Islamic courts, they do exactly the same. They just look who passed away, what they left behind, and they print a schedule. These are the shares, and those shares are final. Now, of course, we can talk later about the issue of, let's say that these are the shares and the wife ends up getting the 12%, and then the sons and daughters say, you know what, we don't want any of that. We want everything to go to mom. They have the full right to do though. But it has to be scheduled, it has to be recognized, and everyone has to do with their full consent that, for example, the boys will say, alhamdulillah, we're well off. We want everything to go to our sisters. With their consent, everything goes to afterwards. But that's the process. So usually when we have anything, the courts issue those shares, and those shares are final, inshallah. So it all depends on each situation, on each case, who left behind. Was there a wasiyah? Remember, nothing gets distributed except after the fact that we have to clear first. If someone said, well, I want 1/3 first, so the 1/3 has to be subtracted. So now it's not 100,000 anymore, it's less. And then we have to know all their debts. So they owe this person this, and they owe this person this, they owe that person, it has to be subtracted. So it ends up being now down to 60,000, it's not 100,000 anymore. So those shares get, that schedule now is based on the 60,000, is no longer on the 100,000, and this is so on and so forth, inshallah.
Just try to.
This is a very good question, sister, and I think that from an estate planning standpoint, I can speak to one part of it. The sister is asking if there's joint assets and bank accounts, shared assets, both of them are working, both of them have assets. God forbid the husband or the wife passes away. So how does the distribution go? Would the wife get 12.5% plus the 50%, whatever that counts? Or how does that work? Well, from a will standpoint, the estate attorney will put whatever you want in there, right? But let's take a step back. From a financial planning standpoint, when I'm encountering with this situation, I tell people, okay, the first question I ask couples, do you do things joint or do you do things separate? And if you're doing things joint, how are you doing it and what's the reason? We got accustomed here in the US, a lot of people are doing everything joint, right? Because that's how the way it is. But if you look back home, it's very rare that you find people doing things joint. Everything is separate ownership. It's set up that way back home, wherever back home is. It's because of that, because it makes it much more simpler in terms of distribution and estate planning. So let's take a step back, and when we're having a conversation about estate planning, really everything should be separate. So if the wife is working and the husband is working, her income is her income, and religiously speaking, the wife's money is the wife's money, right? And it's up to her if she wants to share in the household. The man is the one who's responsible for spending and paying money. I know a lot of men will hate me for saying this, but that's how it is Islamically speaking, right? So separate. Now, if you want to have joint accounts, let's organize it from a budgeting standpoint. Everybody has their own money, the bulk of their estate. But if you're sharing expenses, that's why a lot of people share assets in joint accounts, because they share expenses. The wife has hers, the husband has his, and then we have a joint account where we pay all the expenses and everybody is sharing in their own percentages. And that's one way of actually precaution. And before we get to that point where everything is commingled and everybody has, and then we have that question, right? So there's a little bit of financial planning as part of estate planning where we take a step back and we look at the specific family situation. And then if it comes to a point where I don't want to do that, we want to keep everything joint. We've been doing that for so many years, we're going to keep it that way. That's fine, but then we're going to have a conversation how we're going to set it up and what percentage of those assets in that joint account is actually hers and his. Is it really 50-50 or is it 40-60? And then how is that going to be drafted within the estate plan? And that's where the team approach comes in, where we can help figure these questions out and then give an answer to Jeff so he can draft the will and the estate plan. Did I answer your question, sister? All right. And I believe we have the sister back there.
Yeah, I just had one question. Can the executor be somebody from overseas, or do they have to be like a U.S. citizen, U.S. legal resident, whatever?
Technically they can, but now there's a lot of hoops they're going to have to jump through. There would have to be somebody local specific with a mailing address who would be, quote, the resident process agent. Well, what does that mean? It's like, okay, there needs to be somebody there with a physical address in case the estate gets sued or to send official notifications. The other thing is there is a lot of paperwork that has to be done with probate when you're handling an estate through probate, and well, they're the executor. Now you're starting to deal with foreign notaries, and is this being accepted, and the court having to look at everything. It ends up being quite a bit. So the usual recommendation is, look, if you can find somebody, at least within the US, we don't have that notary issue, and there can be somebody local for, quote, receiving service or process as that agent. Okay. Okay. Well, actually, that's a good point. What happens if you don't have anybody that you would trust in order to do this work, that, quote, first financial person? Well, I do end up highly encouraging people to find those individuals that they would trust. And if, okay, I always find 3 people if you can. So there's a first person, a second person in case they can't do it, and a third just in case backup person. If you don't have those 3 somewhere in that list, you need, quote, a professional who's going to be a trustee or an executor. So typically, I recommend first, there are professional trust companies that will handle that work. This is what they do. Under that, there's banks and bank trust departments, and I tend to say, no, if you can, let's go with a trust company before that, because banks are still notorious for, throughout the process, they're just going to liquidate everything, put it into bank CDs until it gets distributed. And of course, they're going to put the money in their own banks. All right. And then kind of third, that's where you would have someone like me, an attorney. Well, why are we dead last when we're supposedly, this is what we do, we're attorneys? Well, it's because I charge my hourly rate, and believe me, there's nothing that I can do better than those trust companies, and in the end, it's going to be less expensive to have them do it. So I highly encourage looking there. But if you've got people that you can put first, put them first.
We're going to take 3 more questions. Yeah, I'll go take 3 more questions, and then if you have specific questions for the imam or Jeff or Ahmed, we'll take them next door and go to them.
We'll be here for another 30 minutes next door and we can answer.
Okay.
Assalamu alaikum. I have a question regarding the retirement account or 401k. What is the useful or uselessness of giving the beneficiary on those funds? I nominated my children and wife like percentage wise. is that when automatically be enrolled after I passed away, or it goes to the probate?
Well, no, okay. On things like 401ks and IRAs, if you list the beneficiaries, it does bypass probate. You still have to list it on one of these initial forms, but it does bypass that probate court system and goes directly to the beneficiaries. If it's something like a stock account or a bank account, you still have to list it on the inventories, even though technically it's not part of probate. But an issue that I've seen come up a few times is even though it's not part of probate, it's part of the bank procedures to request paperwork from the probate court. And they're only going to deal with the executor. It's like, well, wait a minute, this isn't in probate, it's not supposed to be. It's pay on death to the beneficiaries. But I've just seen that start to happen a little bit. If you're using a trust, all right, having the trust own the bank account, the stock accounts, that makes sense. It doesn't make sense for IRAs and 401ks just because of the tax implications. The government says if you have your trust own an IRA, it's as if you pulled out all your money. But I also haven't seen any issues with companies that have specifically life insurance and IRAs with a pay-on-death beneficiary where they're trying to get court paperwork.
Okay. Assalamu alaikum warahmatullah. I just want to know if there are any document to sign to avoid any autopsy after you pass away.
I don't know of a specific document, but the place that I would draft that into would be the last will and testament, as well as putting it into the healthcare power of attorney, if that's what you want.
There's also a question of the Sharia with consent, everyone. Do you consent to autopsy, and for various reasons, why do you not provide it?
Yeah.
Assalamu alaikum. So I have a hypothetical question. So a person in his life, he wills according to the Sharia distribution, that my sons will get the half, my daughters will get this person, my wife will get 1/8%, and he passed away. The problem is that regarding his home, he does not own the home. It's not under his name. By default, home is supposed to be under his name and his wife's name to begin with, actually, by the state law, or the law over here in the United States. So how that will work, actually, because you put the will in there which you own and you possess. This, by default, you don't possess. You're not a single owner. Your wife is the owner of that home along with you. And what if she disagrees that by end of the day, if I go by his will, I'm going to get just 1/8%, and if I don't agree to this, I will get a lot more than that. How you will tackle this situation?
Yeah, well, this is actually coming back to one of the things that I mentioned about your assets need to be lined up with your plan. If you have a will, and the will says, here's where I want things to go, the will only governs what goes into probate. So if you can own your house in just your name. You don't have to have your spouse on that house, but most people do. And the way it's typically set up with a married couple, it's by something called tenancy by the entirety. Basically means it's joint and there's a right of survivorship on it. Okay, that means it automatically goes to whoever survives and doesn't come under that will. So that's what the result would be. Now, if it was like my grandfather and grandmother on the deed, this was the issue. It was 50% my grandmother, 50% my grandfather. His 50% would have been governed by the will. And his will said everything goes to my grandmother, but it was in probate and it got tied up in that. But if his will had said, no, it's going into being distributed a different way, well then, okay, that's how things get divided up, is according to his will for his 50%.
If I wrote my will on any form, got many witnesses, and had it notarized, I passed away. Do I need my will to be probated, or is it going to be executed tax-free?
Okay.
Is it an income for the children?
All right, that's actually two things. First, it's going to have to be executed and administered by the court because it's a will. So whatever's in there. Taxes are a completely separate issue. Now, I can tell you with North Carolina and estate tax, that's okay, what did you own when you passed on? Doesn't matter if it's in probate, doesn't matter if it's in a revocable trust that you've controlled. If you control it, it's part of what gets looked at for estate taxes. Now, the good news on that tax end is North Carolina doesn't have its own estate tax, it's just federal. And right now, unless you have more than 12.96 million, is it 96 or 69? 12.96 million, so it's almost 13 million. There isn't going to be any estate tax. So that's the estate tax. Income taxes are a different matter because if it's an inheritance from a retirement account, that needs to be handled the right way to minimize what the income taxes are for the beneficiaries because it is 100% income taxable. So, and tax that's separate from whether or not it goes to probate.
How can we avoid paying taxes on my own money that I'm giving to my own children? What's the cheapest way? Least expensive way?
I could probably write you out a 1,000-page book and still not even be halfway through the potential. We'd have to really take a hard look, and this is something that the team approach would be very valuable in getting what you want done, the way you want done, and looking at all the tax angles. I've always found it's very, very valuable to have all of those professionals looking at your plan together.
Before we do that, I want to add something to Abu Rakan. So that's a very good question, and everybody's situation is different. And I can, as Jeff said, we can give you 1,000 answers to that. It really depends on the type of assets that we're talking about. But I just want to take a step back. It seems that there's a confusion on the probate. What does probate mean, right? So, and I tell people when we're thinking about your assets and estate, probate is basically any assets that does not, in general terms, and correct me if I'm wrong, Jeff, you're the expert here in that doesn't have a beneficiary. So any real estate, your business ownership, your bank accounts, all of these are probate assets. And what does that mean when we say this is a probate asset? It means when you pass, even if you have a will and it has a distribution, the executor still has to go to the court, issue a death certificate, and go to each entity that's holding that asset, whether it's it's real estate, you go to the county and then you change that. That's a process that's going to take between 6 months up to 18 to 24 months if everybody agrees and everybody's happy together. But if somebody disputes that, it takes more years. And then that process is costly, and it can cost anywhere between 4% at a minimum up to 10% of the value of that estate. So, and that includes any probate asset that doesn't have beneficiary. Now, any accounts like investment accounts, IRAs, retirement accounts, these are non-probate assets if it has a beneficiary on it, if you have assigned your beneficiary on it. And if you do, that's a non-probate assets, and it goes right through to the beneficiaries without going through the probate process. So, having said that, we always, as a general rule of thumb, people ask me, okay, should I go to a full-fledged estate plan and do a trust, or do I stick to the basic will? And the answer to that, it depends on your assets. If you really have assets to the north of 250 to 500,000, 4 to 10% of that is the equivalent of what it would have cost to create a trust. So it's probably better to create a trust documents, put everything in the trust, make sure it's fully funded, and avoid the court and the probate altogether. Having a trust, which is a part of an estate plan. A trust, yes. Now, the trust has a will inside of it.
Yeah, but it will save all the taxes and all the...
It will not save the taxes. Well, the taxes, the taxes, that's a different conversation, and it depends on your assets. Now, there are ways where we can avoid taxes. There are ways where we can avoid a lot of things. But we need to really have a conversation with you to look at those assets. And trust is the first step of the way. And then, I've been waiting. By the raise of hand, let me ask everybody here. So before we take more questions, let me ask everyone. So we have planned to be in the community room for another 30 minutes to take one-on-one questions and answer personal questions. By the show of hands here, who have generic questions, not specific to their specific situation, that they would like to ask in the public? Just show me. Okay, 1, 2, 3, 4, 5, 6, 7. So about 8 questions here. Are you guys all waiting if we go a little bit over and ask those questions? Answer those questions so everybody can benefit? So the website is Sharia Wiz, and Kashif can give you the coupon codes. Are you guys okay if we go a little bit over? Okay, so we'll take a little bit more question. Brother.
Yes, I will. Assalamu alaikum. Some of the question you already answered, but one question is not clear. Usually your residence, that's a big investment, and your wife's name is, I would say 90% of the time, it's on the title. So when you die, according to state law, it's going to go to my wife, basically. And am I correct that the state law is going to, or federal law is going to supersede any will? Number one question. Number two question is, can my wife and I write a common will? That's number two. Number three is for the masjid. Does masjid has at present any endowment? In other words, how rich is this masjid anyway? Do they need our help or not, or what?
Okay, question number one, it depends on what's on the deed. Because like I said, it's not some automatic under law that if you're on the title alone, oh, it has to go to my wife. No, it doesn't. If the two of you are on that deed and it's done, quote, tenants in common, that means there's no right of survivorship on it. It's 50-50. Your wife keeps the 50%, your 50% goes according to your will. So it's really dependent on the title. There's nothing in the law saying it. It has to. Now, the law also does say that the wife is entitled to a certain percentage. Now let's get into the second question. Can you do a common will? I have nothing but horror stories from looking at, quote, one will for both of you from law school and from other attorneys, but having, quote, reciprocal wills, meaning you each have your own will, but they're basically mirroring the same provisions. Well, okay, that's fine, and that's done all the time. Third question is, what was the third question? You got that?
So that's a very good question. Kashif, can you pull up like some of the numbers? Maybe you have that.
That's the whole purpose we're here today, actually.
So that's part of the reason why we're doing this today. So IAR, alhamdulillah, it's well off. It's a community that grew over the last 40 years. Today, IAR has an annual budget of about last year was 4.15 million of spending. The bulk of that money is coming from donations. So community support. People are supporting the masjid, and we're raising that much money every year. Alhamdulillah, a lot of community members. A lot of that money is also coming from programs, paid programs, coming from grants, and we're able to create and do all of these things, right? But thinking to the future, nonprofit organizations around the US cannot sustain by continuing to raise funds and doing fundraising all the time. So that's why the IAR fundraising committee and the endowment committee started years ago in 2008 and started an endowment fund with $10,000. Today, that endowment fund is a little over 3.5 million, approximately. Now, that endowment fund cannot be touched until it reaches to a point where the income generated of that endowment fund is paying for all IAR's expenses forever. So to give you an example, there's a lot of great endowment funds in the country, and they're in the billions of dollars. Now we're not talking, maybe one day, many, many years down the road, we'll get to that point. But today, what we're aspiring for is that by 2030 to get to 30 million. And today we're at 3.2, so we have a way to go. And then we're planning these programs to educate people and provide information to help us to get to that goal, because I serve as a fundraising chair for IAR, and as a financial advisor, I know it's not sustainable for us to continue to do fundraising all the time. The community is getting bigger, but that means more expenses, that means a lot more things. We need to be creative and work like other religious faith groups do, like the Mormon Church, who have billions of dollars of endowment funds. That's the way to go of the future. So to answer your questions, how well off is IAR? I think we're doing good. I think we're able to cover our own expenses. We're living month to month today. We have an aspiring retirement plan for IAR that at some point, years down the road, we don't need to do fundraising, right? And the way we're going to do that is through different ways. Planned giving as part of your estate. If you're preparing your estate plan and you're well, and you feel compelled to give to charity, you've seen IAR and the work that it did. We have an endowment set up, and we would love to be part of that, right? And by the way, our endowment has been doing great since 2008. We're averaging about,
This is the 13th,
this is before, yeah, this is not the new numbers. It's been averaging around 17 to 18% annual return since 2008. So we have really good track record performance from an investment standpoint, investing that money and growing it.
Where are you investing those endowments?
So right now, the bulk of this is invested in Sharia-compliant market investments, so stocks, mutual funds. We had real estate investments as well as part of that gave us a lot of good return. So it's a very well diversified portfolio. Yes, so it's all on the website, it's all online, and if you want more information about it, you can reach out to Kashif, and then we're happy to provide any information. This is all public information with full disclosures.
So if you want to scan this QR code, you can learn more about the endowments, and within the next week, we'll actually be sending out more information about this,
yeah.
As well as a detailed investment policy summary, basically what we invest in, why we invest in it, kind of thing.
And I'll close that answer with two more things. So in addition to planned giving and estate planning, that's one of the ways that we can give back. There are two other ways. We're opening a zero loan opportunity for the community. So if you have a lot of cash that's sitting there you're not utilizing, you can give a zero loan for a certain maturity to IAR to help us continue to grow, and you get your money back after a certain period. We keep the growth. And then the third option would be mudaraba, an investment agreement. So you have the cash, you don't want to invest it on your own. We can invest it, we have the track record, and it's a partnership agreement. And at the end of the maturity, you get a return, and then IAR gets to keep a certain percentage for their management of that investment. So these are some of the ways that we've been growing endowment to help IAR become self-sufficient and financially free at some point in the future. And to Imam Muammar's point, those who start earlier gets the most recognition. We'll get another couple questions.
Yeah, first of all, Brother Ahmed, thank you very much for the definition of the probate. I think that was good. My question to you, what's the difference between a trust and a revocable trust?
All right, a trust is essentially an agreement. It has a trustor or a trustee and a beneficiary. The term revocable just means you can revoke it and amend it and change it at any time. So now we're kind of getting a little bit into what are some of the different types of trusts. The most common one used for estate planning is the revocable living trust, because you're maintaining control of it as your own trustee during your life. If it's going to be something like an irrevocable trust, well, now there's got to be some additional purpose other than just estate planning. And we do a lot of work with irrevocable trusts, particularly for seniors, if what they're trying to do is put their assets into the trust, and then 5 years later, they may need to get Medicaid to pay for long-term care. But at that point, they can't be the trustee of their own trust. They may or might not be a full beneficiary, a partial beneficiary, or technically not a beneficiary at all. I've also seen some very good developed trusts that are to prevent lawsuits. So if you're a physician that's in a kind of very lawsuit-friendly area, like OBGYNs, one lawsuit could cost tens or hundreds of millions of dollars. All right, they're going to use an irrevocable trust as a way to shelter some of their assets from those potential lawsuits. So there are lots of different kind of trusts that have different results from it, but if we're just talking about estate planning, for the most part, it's the revocable living trust.
Yeah, any question?
I think I do. Assalamu alaikum. So does that mean your LLC, your business has to be in the LLC name to protect the business? Or you could just put it in the trust and that protects the business?
I'd usually say if you're concerned about potential lawsuits, is you're going to do both. You would have a limited liability company or some type of corporation that's going to hold whatever those business assets are, and then to incorporate it with the estate piece, those shares or interests may be owned by your revocable trust. If it's for lawsuit protection in addition and it's an irrevocable trust, well, now maybe the irrevocable trust is owning those shares and interests and you've put them in place. Anytime you're dealing with an irrevocable trust, we definitely need that CPA as part of the team because the taxation could be wildly different depending on what the situation is.
Assalamu alaikum. My question goes back to when you mentioned the courts and the banks. So you have the executive of your estate, and let's say you're gone and they try to go to the bank to get whatever their benefits are. Then you said some banks go by the beneficiary, which I already noted. I noticed that in banks now, when you have accounts, they want you to give them the beneficiary's name, you know, which is different for me to know. But then you mentioned that sometimes the banks require you to go to court and get a death certificate.
Well, yeah, there's the death certificate, but then the, quote, permission papers for the executor. This is just the general overall process. You're filling out an application to become the executor under a will, or it's called an administrator if there is no will and you've opted for the state's guidelines. Okay, that person who's in charge ends up going to the court and they go through it and then they give you your permission papers, your, quote, letters testamentary. What I've seen is some banks, even though there was this pay on death beneficiary form, the beneficiary's coming forward and they're saying, okay, we need you to fill out this form, we need a copy of your driver's license, we need a death certificate, and we need copies of the letters testamentary from the court. So, well, wait a minute. This isn't going through well, that's just something that we need. Again, I think if I got on the phone and started yelling and screaming, this isn't supposed to be part of probate, they'll go, well, it's required, I'm going to have to contact the legal department, and eventually it might get sorted out, but that's also time. And it's a frustration that a lot of my clients don't want to have, so they may put that account into the trust to avoid it. But you're correct, it shouldn't have to have those papers from the court. It's just something that I've seen over the last couple of years.
We'll take one more question, and then we'll be here to answer someone who didn't ask. Okay, we'll take two. One from the side. Let's do the sister first, and then the brother here. And then we'll be here to answer any personal questions.
Inshallah, this is a simple. Anyway, like, what is the downfall of this idea of putting titles in joint right of survivorship in an offspring that's trustworthy? and then letting that offspring just execute an Islamic will?
Well, do the legal part and I can...
Okay. All right, it's because at that point, legally it's theirs. They don't have to divide it up anyway. They can do whatever they want. The other, do you want to handle the taxation part, like say for the house and capital gains and whatnot?
Sure.
Okay, so the legal part is they don't have to do anything with it. Even if they're attempting to do this, and I actually did a video on this on my YouTube channel pretty recently, what if they pass on and they had left everything to the other beneficiaries? Are they going to then necessarily honor those plans to go back to the previous will, or are they just going to go ahead and go forward? And the example I gave in the video is, if it is, everything, I want it divided among my 3 kids, but I'm just going to leave everything to the oldest son and he'll take care of it, and then he has it set in a joint account, and then he passes on, is his widow going to give everything to the former siblings-in-law, or are they going to say, well, all this money's mine, I went to see an attorney, they said I don't have to give them anything, and the kids have to go through college? So yeah, that's a legal piece of it, but there's also a tax piece of it.
So the short answer, don't do it. Because it encourages, or the implications is a lot of taxes. So to Jeff's point, it's their assets, technically speaking, from a legal standpoint. But even if they want to give out those assets and distribute it per the divine distribution, there is a limit on how much you can gift to other people. And that's $15,000 a year today. Or is it 16? 17 today? Yeah. It's $17,000 today. That's the maximum you can give to any individual year. So if you're leaving, let's say, a bank account, and you have a TOD on that bank account, $100,000, and there's 2 siblings, it's going to take that person a couple of years to be able to distribute without paying any taxes. And if they want to give it right away, they're going to be paying a lot of taxes. Now, this gets even more complicated with assets, houses, and properties, because you cannot give small shares, or you can, but it's a painful process. And if you're talking about IRAs and retirement accounts, that's even a nightmare to even think about, because there's penalties, capital gains, taxes that are involved. So don't do it. Get that divine distribution, set the beneficiaries as it should be, do the calculator. It's free online. You'll get the percentages and set it as it needs to be. And everybody gets their fair share with the least amount of effort and taxes that way. Does that answer your question, sister? All right. The brother.
Jazakallah khair. Are there any minority opinions by respected scholars within Islam which have a different interpretation of the shares assigned in the divine distribution?
So as a simple answer about the shares themselves, it's unanimous, but there are difference of opinion on some of the branches of how to finalize the amount so it can be distributed. So just as a short answer, because the shares themselves, those are divinely set by Allah in the Quran. So those are unanimous. What they have differed on is branches of this. So again, the son is not worthy because he has maybe denounced Islam, for example, but he didn't do it publicly. So they differed on this. They differed on the fact that if you would to have a debt, and that is, let's say, just a debt, let's say the mortgage thing, right? Whether you should sell off the house and make it part of the last amount before it gets distributed, or that dwelling is not to be part of the final distribution, because that's what shelters the family. So no one gets to have any of that. So the branches, they differed on the branches, but the final shares, those are divinely set by Allah in the Quran, and no scholar has come to differ on those. Are you guys taking questions? Or?
We'll take 2 more questions.
Thank you so much.
Two more questions, and that's it. Let's start here, and then we can take the brother.
Can we have one sister, please?
Yes. We'll do 1 brother, 1 sister, and we'll do the rest in private.
So, is it on? Okay. Just to add to that part, I mean, what if you have 3 homes and you gave it to 3 kids? Then you have to take the part of that part too for divine.
If you transfer the ownership, then it's not yours anymore in your life.
Okay.
But if you just gave your own house for your son and daughter to live in, that's still your house, and those are not are only the family house is the one that they differ on because it's the household dwelling. I mean, this is what shelters the family.
No, when we create the living trust and we specify we have 3 homes and this home goes to this person, this person, this person, after we passed away. So that still implies to that.
So remember, we can't have it all. Like what I said in the beginning, you have 2 options and only 2 options. Either you give up your right while you're alive. So you assign those 3 homes. This is for my son, this is for my daughter number 1, and this is for my daughter number 2. You have transferred position in your life. These houses are no longer yours. Option number 2 is after my death. After my death, you cannot assign. This house is for my son, this house is... After death, it is only one that all your wealth gets calculated together, including those 3 homes. Everything. Your 401, your retirements, your investments, your bank accounts, everything gets in that pool. 1/3 goes out. If you assign 1/3 goes to the masjid, gets subtracted, and whatever debts that you have gets subtracted, and the final number gets distributed. So those are the only 2 options that we have. We cannot live and then say, after my death, this is what I assign. We can't do that. So we have the option either to give it up while we're alive, or after death, it has to go with the divine, the distribution, which means that it has to be all put together, everything, and then final number will be distributed with the according shares that we talked about divinely.
What if you added your wife and kids to the title of your wife and yourself? Brother, let's answer this one-on-one after let's allow this to ask a question and then we can...
How often do we have to update these documents, and do any of these documents expire after a certain amount of years while we're living?
It's a very good question, and I think,
they don't expire, and you can update it any time that you want, but just in my experience, it's about every 5 to 7 years that people are re-examining the actual documents because they're changing the people that they want doing things in making some of these documents effective. But it should probably actually be looked at least once a year just to make sure everything is still on course. And if it's also done in conjunction with the attorney, the tax person, and the financial person, now we're looking at a big picture once a year to at least keep everything on track.
Yeah, as a general rule of thumb, what I tell my clients, we want to look at everything during an annual review, make sure that we're looking at your estate plan, if anything has changed, life events, anything needs to be updated. For the most part, I don't see a lot of changes happening. Probably every 3 to 5 years, it's a good idea to do an extensive review of everything. And when life events happen, if one of the beneficiaries or trustees are no longer with us, if divorce, marriage, new children. So these trigger that you need to make updates on your estate plan. And with that, Jazakumullah khair. Thank you all for joining us. Please join us in the room next door for refreshments. We'll be there. I'm going to be there until Dhuhr. Jeff, if you're available, you can join us as well. and then we can answer any one-on-one questions. We have some promo codes.
We do. We'll give those out.
For Sharia Wiz, for those who just want a basic will online, we have those promo discount codes. You can pick them up from Kashif. And Jazakumullah khair. Thank you for joining us all.
And we encourage everyone to scan this QR code, to stay in touch. We'll give you some financial advice and financial tips throughout the year.
Yes, we can clap. I know what I want to do.
Okay.
You know, the question is, can I get started?
Oh, and real quick, if anyone wants a flyer or a handout, I have more copies of those.